Hello friends, today in this session we are going to discuss the case Brij Narayan vs. Mangala Prasad 1924-51 AIR 139. First, let us briefly understand this case. In 1908, Sita Ram mortgaged the ancestral and joint property for rupees 11,000 in 1912. A unilateral decree was issued, but it was set aside due to the inadequate representation of the sons. The opponent claimed that the mortgage was binding for the repayment of a previous debt, but the learned judges dismissed the appeal since there was no clear evidence regarding the use of the funds. The, the Privy Council held that under Hindu law, the sacred obligation of a son to repay his father's debt is well established. Ultimately, the Supreme Court allowed that the appeal and stayed the decision of the lower courts along with the costs. Now let us study this case in details. Answer: Mr. Brij Narayan Plaintiffs versus Mr. Mangala Prasad Defendants, reference 192451 AIR 139. Issue: is the mortgage placed by a father to discharge a previous debt binding on his minor sons? Facts of the suit: on March 4, 1908, Mr. Sita Ram mortgaged the ancestral and joint property in favor of Mr. Raja Narayan Vs. and Mr. Jagdish Narayan Rai for rupees 11,000. The current loan was taken on the same property to pay off two earlier loans. At that time, Mr. Sita Ram was acting as the manager of the mortgaged property, and the joint family also included his two minor sons. In 1912, the mortgagors filed a suit on the mortgage and obtained a unilateral decree in 1913. The mother filed the present claim on behalf of her two minor sons, who had by then reached majority, declaring that the mortgage was not binding on them and that the decree was invalid and void. Mr. Jagdish Narayan Rai assigned his interest to his brother Mr. Raja Narayan Vs., who appeared in defense and argued that the mortgage was executed to discharge the previous debt of the plaintiff's father, hence it was binding on the property. Lower court: the subordinate judge found that at the time the unilateral decree was issued in 1912, then sons were not adequately represented. Consequently, legally the plaintiff's sons were not bound by the 1912 decree, and the decree was set aside. Court of Appeals: the defendants appealed. The learned judges concluded that it was impossible to determine with certainty the exact purpose for which the funds raised by the two mortgagors were used, or whether the loan taken was entirely expended irrespective of the family property. Accordingly, the dismissed the appeal. Privy Council: an appeal was filed before the Privy Council. Against this decision, the court held that under Hindu law, the sacred obligation of a son to pay his father's debt is well established, whether the father is alive or deceased. The appeal was allowed and the decisions of the lower courts were stayed along with the court's legal principle established. Point 1. A manager of a joint undivided property cannot partition or impair the property without proper cause, taking into account the requirements of the co-owners. Point 2. If a father is present along with his other sons, he may obtain a loan provided the loan is not for an immoral purpose and for the purpose of repaying that loan. He may retain his rights over the property as contemplated under an execution decree. Point 3. If a burden is placed on the property in the form of a mortgage, then until the mortgage discharge a prior loan, such a burden does not create a enforceable encumbrance on the property. Point 4. The term prior loan signifies not only a loan taken earlier in the time but also one that is independent and not part of the current transaction. Point 5. There is no rule that differentiates based on whether the father who has contracted the loan or encumbered the property is alive or deceased. Please watch full video, share and subscribe to the channel. Thank you.